All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning.
Good morning.
We are here for oral argument in our case number CV24 0754 Heshion v. Gentry Wealth. These proceedings are being video and audio recorded and live streamed. So we ask you to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. The appellant's counsel is responsible for watching the clock to reserve a portion of that for rebuttal if you'd like. And I understand somehow between the intervener and appellee will split that time amongst yourselves. Also, please keep in mind that we've read the briefs and have conferenced the case this morning, and with that, counsel, you may proceed.
May it please the Court, my name is David Abney, and I'm here on behalf of Thomas Heshion. It's always an honor to be here. Sometimes I have something witty to say at the beginning of an argument, but today I'm all
Don't disappoint me.
Pardon me?
Don't disappoint me.
All right. I'm coming up blank. Well, I did saw the Fever got blasted out in their second game in the playoffs, and I'm hopeful when they get back to Indianapolis, they'll be back in form. I know Caitlin won't be playing, but damn, they're a good basketball team. I love the way they pull together. And there's a segue there, because when everything is going wrong, it looks like a disaster, they still keep fighting. And I think everything's going wrong in this appeal, and I'm going to still keep fighting. I'm not sure which issue to start with, or even if the Liz Pendens issue is on the table in this particular appeal. My opposition across the hall says it's not. And if the court wants to entertain some argument about the Liz Pendens, I'm prepared to argue about that. And if not, I'll toddle over to the other issue, which is the prosecution of the case.
I mean, you have another appeal that's pending. I think it's set for oral argument in October.
Yes.
Okay. How can you have the issue raised twice with two different panels?
Darn if I know.
And I guess how, as a court, do we decide which of the two should move forward and which shouldn't?
I don't know. I tried to consolidate. I filed a motion for consolidation with the court, and the court denied it. And I'm not sure why, but it happened. And so I'm not sure where I need to argue this, or if I lose something by not arguing it in both cases. But so it's up to the court. The other case really is more on the Liz Pendens, I believe, than this case, but I didn't want to lose anything, because it's a Rule 54C judgment. That's the problem. If it said Rule 54B, then I think things would be much narrower, but it was a Rule 54C. So when I see that, it's like, well, all claims, all parties, here we are.
But I guess, did the Liz Pendens identify the litigation that's primarily at issue in our appeal as the basis for the interest in the property, or the litigation in the, I guess, for lack of better description, the 2021 case?
I think the other appeal is more the Liz Pendens, really. So, I mean, if we go forward today without worrying about the Liz Pendens, and this court says we're not worrying about Liz Pendens in whatever decision, then I think I've protected my client and can go forward with Liz Pendens. The thing about the other appeals, the client got hit with massive attorney's fees, costs, sanctions, everything for supposedly filing an improper, worthless, whatever the term of art is, it's escaping me.
Groundless.
Groundless, that's it. Groundless Liz Pendens. And he got hit over the head with this massive amount of money. So that's really, if the court wants to set that aside and let it go with the other appeal, I'm fine with that. I've done my job, at least.
Okay.
And that leaves me with a very narrow argument, really. There was a lot of activity in this case. It was like heading in different directions and unfocused and intermittent. There'd be stops and starts along the way. And I laid out in the opening brief and in one of the answering briefs, they had a timeline of all kinds of different activities that were going on. And you could see the trial judge was naturally frustrated with this sort of goo. It wasn't moving along at all. And then toward the end, things finally coalesced, and they had a joint pretrial statement. The parties had agreed to one of the more unusual things I've ever seen. It was a 3-hour trial They wouldn't be considering the deposition transcripts. They're just 3 hours, and they'd be in and out. They agreed in their joint pretrial statement that they provide statements of the case, a mutually agreed set of the stipulated facts, 3 sets of disputed facts, a short set of agreed issues of law, the disputed issues of law, witnesses to be offered at trial, objections to them, although I don't see how many witnesses you're going to really offer in 3 hours, but 3 sets of exhibits, and then their 3-hour estimate of the time of trial.
What was the issue that was going to be decided in that hearing?
It was going to be Mr. Heshion, I believe it was going to be Mr. Hession's rights and liabilities in relation to the litigation itself. Did he, was he entitled to win anything? Was he going to lose? Basically the merits of the dispute was going to be litigated to the extent.
I thought it was about whether the receiver could sell property.
No, I'm pretty sure that would have already been decided with different orders, giving the receivership authority to go forward, separate orders. And of course, the receiver here can.
Right, there's 2 issues. Do I appoint the receiver?
That was
yes
already,
or no? I know that was, I think, decided.
Yeah,
at the time the pretrial management statement you're talking about was filed. And then there's a later issue about, okay, the entity over which the receiver has been appointed owns property. Should the receiver, I guess, be permitted to move forward with a prospective sale of that property?
I think that was after the dust settled. I mean, after this was done and Heshion was basically finished.
So you don't think that sale issue was part of the hearing, or I guess the entirety of the hearing, that pretrial management statement was
I
being
don't
followed?
believe that was what was going on.
Okay.
And if I'm wrong, I'm sure my colleagues will be happy to correct me.
Well, I guess if you're wrong, how does that impact your argument about
Well,
whether the court abused its discretion in dismissing this case?
Well, the parties had agreed to a trial, and the court, that would have been a central part of resolving the case. And if you get rid of that, then, my client really has nothing. So,
But the sale of the property would, assuming I'm right that that's what the issue was, that sale would have been part of the 2020 case, right? Not the 2021 case.
I think it's all consolidated and related. I mean, what happens to the property is the central underlying theme of everything that's going on. The disputes and everything else is about who owns 1881. And the only thing, even the receiver will say, the only substantial assets that this company, that 1881 had, was real property. It had a lot of it. It had leases to a whole bunch of real property, 14,000 acres, I think. It owns 7,000 acres. And the dispute was really what's going to happen to the property. And in fact, after the case ended, but it's part of the record, and I even attached an exhibit to the opening brief, I believe, in this case, the sale went through like, boom, it's done. Yeah. So it really was all about what's going to happen to this property. And Mr. Heshion...
I thought the 2021 case was about whether the operating agreement had been lawfully amended.
That was one of the issues, but it wasn't the whole thing. I mean, the lawsuit against Heshion and Heshion's lawsuit against them really centered on what's going to happen to 1881. And what's going to happen to 1881 takes us back to the lis pendens and the fundamental problem here, what's going to happen to the property? And then who's going to get the money after the property is sold is really a correlative issue. But the big problem is what's going to happen with the property here? Who's going to own the property? What are the ownership rights, equitable and otherwise?
I would think your client would care about what happens to the money even after the property is sold.
Well,
I thought he was saying, I own more of this, or I have more of an interest in this than the amended operating agreement purports to give me. It was illegally amended, and therefore I get a bigger piece of the pie, whatever that pie is made up of, property or funds.
That was one of his fundamental positions, absolutely, sure. But it all goes back to the real problem, underlying problem, what's going to happen to this property? If you solve that, then you get to the subsidiary issue, well, where does the money go once you actually decide what happens to the property? And then everything we sort of drift back into the lis pendens problem. They claim everything fell off the rails because of the lis pendens and the loss of the litigation and everything else was gummed up by the lis pendens. Of course, the lis pendens was resolved moderately quickly, but still it echoed throughout this whole case. What happened there derailed everything else according to them. But really, lis pendens, it's just notice to the world there's litigation that could affect the ownership of property. All right.
Was the Superior, before you get going again, I apologize, counsel, just a little fact question. Is it correct that the Superior Court concluded that your client hadn't made Rule 26.1 disclosures?
He had not made proper if Rule 26.1 disclosures. So as far as I could tell.
So the court concluded that and the court was correct?
I believe so, Your Honor.
Okay, thank you.
But then again, there were peccadillos on the other side as well. People were not adhering to the scheduling orders that had originally been put forth. And then finally, they
Isn't the remedy for that for you to move to dismiss their claims for lack of prosecution?
that is a remedy, but another remedy is to say that everyone has not done exactly what they're supposed to do, and let's get this back on track. And they did. It looked to me, from the record, that they really had. It's sort of our two parallel things going on here. The parties had gotten together, and they came up with this joint pretrial statement with all these things that were going to be done, and all these, occurring at this very brief trial, and then that would resolve really the substance of what was going on. And the court, after that, said, okay, you're done, goodbye, Mr. Heshion, I'm going to sanction you and rule against you, and your case is done. But how can you really do that? Haven't the defendants waived any of their objections when they've agreed to this joint pretrial statement? They've agreed there should be a trial. They set all the terms and conditions and disclosures and everything that's supposed to happen. Haven't they waived their objections to all the other stuff that went before? That's my central premise here. My central premise, my submission to the court, is that they have waived. And should just let the darn trial go forward, get it resolved, and then we're done properly.
So you waive lack of disclosure or Rule 26.1 issues if you enter into a joint pretrial management statement?
Well, it's not just entering into a joint pretrial management statement. In the joint pretrial statement, they outline exactly what's going to happen at the trial. All of the things that are going to happen, the list of witnesses, exhibits, everything, it's all outlined there, and they're set for a trial, and then the judge says, well, because of all the stuff that happened before that, your case is done. That just doesn't seem right.
Our standard of review is abuse of discretion, right, in this one?
I don't think so, because you're interpreting court rules, and when you're interpreting court rules and statutes and whatnot, the standard of review should be de novo.
So in the joint pretrial statement, I think Rule 16B2 and 3 is where you have to state all the things that you both agree are disputes of fact and law. That's B2. And then B3 is, these are the things I think are disputes and they don't agree are disputes, and vice versa. Were B2 and B3 robustly populated? Were all the disputes of fact and law crystallized for the court in this pretrial statement?
Did you say robustly?
Were they all in there? Were they all in there? I didn't mean to get fancy.
No, I think it's a great word. I don't know about robustly, but they were in there somewhat. Significantly, sufficiently. That's my word.
All disputes of fact and law were in this pretrial order.
And if they weren't, yes, but with this caveat, if they weren't, they're done. So if it's in that joint pretrial statement, that's it. And if they're not, then they fall by the wayside.
Put another way, they were all in. Right?
Yes.
And that is what you're saying.
Yes, pardon the tap dance. I didn't mean to do a Chicago here. I really didn't. I'd like to save my time and my sanity, so if I may reserve my time.
Thank you, counsel.
Thank you.
Good morning. May it please the court. My name is Gabe Aragon with the Coppersmith Brockelman Law Firm, and I'm here on behalf of Appellees with respect to the portion of Mr. Hession's appeal challenging the trial court's dismissal of his 2021 litigation against my clients and all the other investors and non-investors that he sued in that case.
Can you explain the fundamental and frankly kind of bizarre contradiction between agreeing to a trial in a joint pretrial statement and seeking to dismiss for lack of prosecution? That seems at first blush irreconcilable for your client to have done those two things.
To address the questions from the court, the points we're hearing are irreconcilable because none of them are true. That joint pretrial statement and evidentiary hearing related, as Judge Catlett pointed out, to the receiver's motion to sell the property. So that was receiver and company business as part of the consolidated case, part of which was the company was a party to. That's the 2020 case. The receiver moved to sell the property. There was an evidentiary hearing. As part of the evidentiary hearing, there was a joint pretrial statement. My clients, as it relates to the lawsuit in which Mr. Heshion sued them separately, had nothing to do with that joint pretrial statement, that hearing, other than they happened to be investors and members of the company, and the company wanted to sell the property. But that's...
Were any of them parties to that hearing?
No.
Right, it's the receiver, right?
Correct. And the only person challenging it, as it relates to this proceeding, was Mr. Heshion. It's a non sequitur. We've heard in the briefs, it's just inaccurate. But that brings us to kind of why we're here, Your Honors, is that what we've heard repeatedly is that this is somehow an exceptional and challenging issue before the court. It's not. A plaintiff, when they bring lawsuits and see fit to use this court and our court system to seek redress against others, it comes with duties. The duty to actively prosecute the case. And what happened here is exactly why that duty exists, is because our courts can be used as a way to abuse people. You file a lawsuit here, he sued around 50 people, every member of the company and others, their families, their spouses, their businesses. He sued them all with the most stigmatizing claims you can imagine, fraud, conspiracy, everything. And they did nothing over 3 years to prosecute the claims.
What about Mr. Abney's argument saying it goes both ways?
Well, it doesn't. It doesn't. And that's where Cooper v. Odom helps us here, because Cooper v. Odom says it's the plaintiff's job to see their case through. There were no counterclaims by my clients back at Mr. Heshion. He sued them. It's his burden, his case, his filing. And so Cooper v. Odom says, hey, this is the plaintiff's job to see the case through. It's not the defendant's job to manage it for them. And so that becomes really important as the court, when we move to dismiss, the very purpose for Rule 41, we brought it to the court's attention. We have years of neglect of this case. And so we bring it to the court's attention. And this is precisely why the abuse of discretion standard applies here, because the trial court needs to have the discretion to call balls and strikes on what's going on in the cases before it.
Excuse me, counsel. So if the evidentiary hearing was sort of limited in scope, what was the remaining scope of the case outside of the joint pretrial statement that his client was failing to prosecute? Can you define the rest of that space that was not being prosecuted?
Sure. That's the 2021 case that he filed against Appleese and everyone else and others relating to the company. So he accused, as I think Judge Catlett and you, Judge Jacobs, pointed out, he accused our clients of fraud, conspiracy, suing for damages, claiming that somehow he was duped out of his membership interests in other undefined areas of damages and claims. So that was the 2021 case.
And all of that was not within the scope of the joint pretrial statement that he's citing?
Correct.
Okay.
Correct. So we raise the issue with Judge Ryan Toohill, and we say, hey, under Rule 41, this case has been neglected. It's his job, it's his case, it's his burden of proof. He's neglected it. And so what does the trial court find? Well, she finds that he's ignored every deadline in this court's scheduling order, and those are firm deadlines, never sought timely to adjust it or raise any good cause. To your point, Judge Jacobs, he admittedly violated Rule 26.1 disclosures on damages, documents, witnesses. So again, nothing is suggested.
And again, those go to the scope of the 2021 suit, and the claims that you clarified are not within the scope of the joint pretrial order he's relying on.
Correct.
Sorry for the interruption. Thank you.
Yeah, precisely. No discovery, no depositions, none of the activities that would be part of diligent prosecution of the claims that the law says you have to do. If you see fit to file a lawsuit, you've got to do something about it, and he didn't do any of that. And he even went so far, as we've noted you'll see in the record and noted in the briefing, he went so far to ignore a specific warning from the court, saying, hey, I don't know what's going on in this case. It's clear there hasn't been activity in the docket. I need a status report. Either the case needs to be settled, or I need a timely status report. He blew that off too. So all of these were issues presented to Judge Toohill.
How far in advance of the dismissal for lack of prosecution was the court's request for a status update?
My memory is that was around August of 2023, and then we went and started to prepare the motion and filed it a few months later. So my memory off the top of my head, Judge Jacobs, it was several months. And again, no activity in between that time, consistent with a plaintiff who actually cared about a case and intended to see it through.
I mean, the interesting wrinkle here is the consolidation issue. Are you suggesting that nothing Mr. Heshion does with respect to the consolidated case has any bearing on his prosecution of his claims? I mean, I guess that, legally, does it have no relevance? Or are you saying we could look to that if he had done something, he just didn't do it here?
Judge Catlett, I think a little bit of both.
Okay.
Legally, they don't merge the cases. That's the law. So they were consolidated for purposes of case management. Both of them have the overlapping piece as relating to 1881. The company, 1881, had sued Mr. Heshion in the 2020 case. That was that dispute. And then he hauled off and sued our clients in the 2021 case. So, and in the 2020 case, he moved to consolidated. So they were consolidated for case management purposes. Again, nothing about that case and the way it unfolded, that consolidated case had anything to do with advancing his 2021 case. So hypothetically, and again, it's contrary to the record here, Judge, but I guess perhaps discovery and activities that actually bear on the merits of his alleged claims in the 2021 case could have occurred in a consolidated fashion where he might actually have something to show for it, but nothing like that ever happened in this case because the consolidated case related to, again, company claims against him, and then largely the receiver's activities in the case, managing different aspects of the company and frankly, its wind-up. So in this case, Judge, the consolidated nature had nothing to do with actually advancing his claims. And that's exactly the same argument that Judge Tuhill also considered and rejected below. Another thing that the trial court was on all fours in her order, she considered the record that was undisputed, including the 26-1 violations that I appreciate counsel admitting those occurred. Those bear directly on whether or not a plaintiff has actually done his or her job. She also cited the seminal cases that matter here, Cooper v. Odom and Slaughter, both of which say that when you have this kind of neglect by a plaintiff, those are grounds to have a dismissal that should be affirmed on appeal. And notably, it struck me as I was preparing for today that both of those seminal cases cited by the trial court and in our answering brief were ignored by Mr. Heshion in this appeal. So again, we have a telling omission as to the law and the record that really underscore where the trial court was absolutely within her discretion in dismissing his case.
What about the motion for summary judgment that was filed?
Judge, that happened months after the deadline, and Judge Tuhill also considered that as well. They filed it like a week before our motion to dismiss hearing. So again, just another example of violating the rules, and frankly in a transparent way, as some kind of stick save that was appropriately rejected by the trial court in her discretion. So at the end of the day,
How about
Judge...
their response to your motions to dismiss or motion to dismiss?
Pardon me?
They responded to a motion to dismiss that your clients had filed. I think that was in the 2021 case. Or I'm sorry, the 2020 case. I guess
At the outset of the case?
Yeah.
Yes. Yeah. So there admittedly was motion practice at the very beginning. Again, standard course in any case. So, and when you sue this many parties, there's going to be a flurry of activity. So what really mattered to the trial court here, and again, within her discretion, is what happened after the scheduling order happened. We have docket activity that showed that had languished before, but let's look at the scheduling order and whether or not he complied. And he didn't time and time again. So at the end of the day, did Mr. Heshion get a fair shake in our trial court? Absolutely. Did he act like a plaintiff that truly cared about a diligent case to manage? Absolutely not. Trial court was within her discretion, and that should be affirmed. I'm going to respect the time I offered to share with Mr. Peterson. So if you have any other questions, happy to answer them, but otherwise I will.
You called it a stick save. That's a hockey metaphor, right?
It is, yes.
So it wasn't like a proper pad save. Like, Heshion didn't put his whole body into it. It was glancing. That's what you're saying.
Judge, are you trying to expose that I really don't know anything about hockey other than occasionally a colloquialism that you've done that?
I just didn't want us to fail to have colloquy with you as we did with your friend over there. Thank you, counsel.
I appreciate that.
Thank you, Mr.
Thank you. I appreciate you.
Thank you.
Good morning. May it please the court, Fred Peterson on behalf of Chris Linscott, who is the court-appointed receiver for 1881 Preserve. have several pages of notes prepared. I'm not really sure because Mr. Abney seemed to acknowledge that there isn't jurisdiction for this court to deal with the portions dealing with the lis pendens. As previously noted, there is a second appeal pending on the very same issues. Several paragraphs from this brief were repeated in the briefing for that other appeal, and it is set for oral argument. It was originally October. I think it just got rescheduled to November because of a conflict. So,
I have a question on jurisdiction. Sure. Appellate Procedure Rule 8D says, failure of an appellant to perform an act other than the timely filing of a notice of appeal does not affect the appellate court's jurisdiction, but the failure may be grounds for dismissal of the appeal. I guess there isn't any question that the notice of appeal here was timely filed. The issue is, did Mr. Heshion list, I guess, the lis pendens in the notice? I'm not sure that failure is jurisdictional.
So Lee versus Lee, cited in my briefs at 133 Arizona 118, says the Court of Appeals acquires no jurisdiction to review matters not contained in the notice of appeal. So that's the basis for me making that argument. That's a Division I decision.
From what year?
Unfortunately, I don't have that in my notes. It's 133 Arizona.
The reason I asked the year is because I think 8D changed such that that old requirement of listing everything in the notice of appeal is no longer jurisdictional.
Certainly. I mean, I think...
Let's assume it's not jurisdictional.
Okay.
You heard me ask Mr. Abney, how should we go about deciding which of these two, I guess, appeals we should decide this issue in?
Sure. So, the purpose of a notice of appeal is to provide notice both to the court and to the parties of what issues are going to be addressed. And Mr. Abney, in this original notice of appeal, appealed from the final judgment on August 27, 2024, which dismissed the 2021 case, and the court's July 3, 2024 minute entry. So I think looking at that minute entry becomes very important. That's the basis for the court's decision. But you see in there it's a motion practice between Mr. Heshion and the Triada parties that the receiver was not part of. If you look at the appearances, which are usually...
When did the lis pendens issue first come up with us on this panel in this appeal, in the case management statement?
I don't remember if it was in
your
his...
Your client was on enough notice to intervene and brief the issue on the merits, right?
It was, I believe in the issues on appeal, he mentioned some, and then in his brief, and following his brief, I did file a motion requesting the court limit the scope because there was already a second appeal pending. The response from the court was to permit me to intervene, which is where this got briefed. So I was absolutely on notice. I'm not arguing I was not on notice. What I'm arguing, though, is the orders he's appealing from, which were final at that time and ripe for appeal, if you look at the minute entry, the appearances, the receiver wasn't part of it. We didn't appear at the hearing. We didn't argue at the hearing. We weren't part of anything for that decision. Perhaps even more important, though, is on the lis pendens issue, it was not yet final and ready for an appeal. That judgment doesn't get entered until January of 2025, months after this appeal has started. And by the way, as noted, there's no dispute that there was also a timely appeal filed actually of that order.
Right.
The order.
So yeah, that you sort of predicted my next question, which is you have not argued to the other panel that it does not have jurisdiction.
I have not.
So there's no risk here that we say we don't have jurisdiction or we dismiss, and then because of this case, that other panel dismisses for lack of jurisdiction, and then Mr. Heshion is out of luck.
Yeah, this is a request to not ruling on it here, but there's no harm to Mr. Heshion. I think he has all of his appellate rights. We have not argued that in the other case. In fact, in the motion I presented to this court, I suggested he would have all his appellate rights in the second appeal. So I think as a tidy way to deal with it, like your question, Judge, I think it is appropriately dealt with in the other case. That's where the order that's really at issue was timely appealed. And as Mr. Abney said, that case is focused on the lis pendens issue, so we think it's appropriate to deal with there. I don't know if anyone else has questions. I think I'm going to pause there. If any other issues come up, though, they are briefed, and we'll just stand on our briefs. So, thank you.
Thank you, Mr. Peterson. Mr. Abney, you have a little over 7 minutes if you'd like it.
I'll just pray for divine intervention here. I'll cut short the prayer and get back to work. I think I've done one positive thing for my client, at least. I hope that the lis pendens issue is protected and this court will not make any sort of ruling that will say it's gone and then the other panel will say it's gone. And if I've done that, then I've earned my $20. For the failure to prosecute, I feel like I'm looking at the south end of a northbound mule. But there was a lot of activity in the case by both sides. It wasn't as focused as it could have been. You get to the point where they're going to have what's labeled as a trial, and they do the joint pretrial statement and get ready for that, and then that just falls away. And in the end, you have a situation where Mr. Heshion's counsel and Mr. Heshion are not as active as they should have been, but the other side was also ignoring deadlines along the way and not as active and focused as they should have been. So my position of the court is there really should be equal consideration here, and that the trial court did not properly handle this case when it just threw everything out and penalized Mr. Heshion for his lack of activity and not the other side for their relative lack of activity. There was a question about...
Let's say consolidation had never occurred and these two cases were kept separate. And I know I'm asking you to speculate, but would you still be making the same argument at that point based on what your client did with respect particularly to the 2021 claims? I'm trying to figure out how much your argument depends on the consolidation and how much it doesn't.
Because it depends a lot on consolidation.
Yeah.
And I'm not sure...
And I'm not saying that's wrong, that it does.
They have that old metaphor, you can't be just partly pregnant. I'm not sure if that's sexist or not, but you just can't, there's some situations where you can't be partly something. You're all in. And with consolidation, you're in. They talk about consolidation for procedural purposes and whatnot, but they were working these cases as one case after that consolidation, and then we get this result. And you file, when you're confronted with the problem is the one I've had before over and over, and I think Paul Ulrich once said, you use the Chicago method. When you see something that looks appealable, you file a notice of appeal. And if there's something changed after that, you file another notice of appeal, and you keep doing that to make sure that your client is protected. And when I see Rule 54C, alarm bells go off, and I make sure there's a notice of appeal filed. It should have been, I think, a 54B, but that's neither here nor there. I think I've said enough without endangering my reputation, and I'd like to stop now, if I may, unless there's further questions. Thank you very much for your time. I appreciate it.
Thank you.
Thank you for your written briefs and your argument here today. We're going to be we'll take the matter under advisement and issue a written ruling in due course. We're going to be in recess for the next argument to set up. We're running ahead of schedule. If the parties for the next argument are ready to start early, we can do that, but there's no pressure to do so. So just let us know. Thank you.